Hi there and welcome to Employment Law Show. We're back for another week. John Scholes, I am. He is Lior Samfiru. Want to reach out to Lior anytime, employmentlawyer.ca. Always use the phone number if you prefer, 1-855-821-5900. The email address we always refer to and you can use anytime, even outside the show, is help@employmentlawyer.ca. I'll give you some more contact information throughout the show as we roll on through this 30 minutes. Our main topic in the next segment is going to be what you need to know about performance plans. Performance plans, that's on the way, and we'll try to get some other content like phone calls from a radio show and a bunch of other stuff. So tuck in, we're good to go. As we get into that, we always start off with the week that was, or case of the day. Lior, what do you got going on?
So I had another busy week, a lot of calls, a lot of questions, a lot of people wanting some help and support with their employment issues. That's what I want. That's what I do. You know, you may think, well, Lior is just some guy that shows up on TV and to talk about employment law. I do that for a little bit of time. Every other moment of my working time is spent in the office, working with people, helping them understand and enforce their legal rights. I get questions about severance packages, about harassment, about discrimination, about accommodation. We can go on. I think you get the idea. If you have an employment issue, if you have a workplace problems, a good start right here on the show. You will learn a lot. By now, hopefully, if you're a regular viewer, you already know much more than you did. And beyond the 30 minutes of the show, we can always continue the conversation off air. You can call me in the office. We can have that private discussion or email exchange. We have a team across the country, frankly, willing, ready, and able to help. So do the right thing because you have rights. It'd be silly of me to come here every week and talk about rights you don't have. Well, you have rights. You have substantial rights. Some of the best employment law rights are right here in Canada, better than many, many other places in the world. Too many people don't appreciate just how many rights they have. Well, I appreciate it, I know it, and I'll tell you about it every week. And a good place to start, a case of the day situation that came across my desk. Well, this is actually three situations that came across my desk over the past week. I spoke several times with individuals that were pretty darn sure that they were let go, at least in part, because of their age. They felt that, hey, they were the oldest or some of the oldest people in the workplace. They were the only ones let go. Over the past couple of years, they heard some comments about their age and about their future. And all of a sudden, they're let go for no reason and replaced with younger individuals. So, yeah, you don't have to be a legal expert. You tell me, doesn't it sound like age discrimination? Well, it is, and age discrimination is illegal. You cannot be let go because of your age. Now, some 20 years ago, we had mandatory retirement. An employer can let you go in some situations when you reached a certain age. Gone, not a factor anymore. You can work as long as you want, whether it's 65, 75, or any other age. It's up to you, the employee, to decide if you're going to leave, retire, resign. No one can force you, and no one certainly can let you go because of your age. Now, in some situations, age is just one of several reasons you will let go. There are several factors. Well, even if it's one factor of many, it's still illegal. So in these situations, it was very obvious to me with these individuals that called me that they were let go because of the age. So age discrimination, human rights violations, so they're owed compensation for that. Beyond that, age is one of the main factors that go into deciding how much severance you get. The older you are, the more severance you're owed. So a 65-year-old individual is going to get more than a 35-year-old individual, all things being equal. So these individuals had substantial severance entitlements, much more than what they've been offered, in additional, of course, human rights damages. So if you're ever in a situation where you feel that your age is a factor, not just in being let go, maybe in the jobs that you get or how you're treated in the workplace, we want to talk about it. And always remember that that severance package could significantly get impacted because of your age.
How does an employer that maybe, you know, their spidey sense is telling them that this may be happening, it's my age, that's why they kind of push me out the door. How do they start to build a case, build some proof that is actually the case and happening?
You know, and that's really the key. In some situations, it's going to be very difficult to show. You know, maybe you're part of several people who have been let go, so it's going to be difficult to show that you're being picked on because of your age. In other cases, like these ones that I told you about, it's just obvious. If you're the oldest person in the workplace, you're the only one let go, everyone else is younger, there's nothing really going on to justify it. Well, gosh, what else could there be? So it may be difficult for the individual to show absolute proof. They're not going to have a smoking gun. They're not going to have an email from the company saying, yeah, we're letting Bob go because he's too old. Not going to happen. But in many cases, and I've done these cases for many years, it's just is obvious. It looks like it. It's hard to deny it, and the company can legitimately justify it. So don't be afraid of that. If it looks like an age discrimination, in most cases, it is.
If I'm an employer watching this show, Lior, now going, well, I've got an employer too who says, maybe they're getting out there in age. I don't want to fire them. They've been generally a good employee for a long time, but they're starting to slow down a bit. How do you suggest what their future plans are without stepping on toes legally, right?
Well, there's nothing wrong with asking the question. As an employee, you want to plan for your future. Mm-hmm. So if you have an employee that's on the verge of of resigning or retiring, you want to know that. So it's okay to ask the question, what are your plans? Or do you have plans? But the key is this: if the answer is, I'm not going to tell you, I don't know, I haven't decided, you leave it be. You don't pursue it, you don't push, you don't try to convince. Beyond that, if you have an employee that's not performing up to snuff, regardless of the reason, you have to performance manage. You deal with them, you provide guidance, help, support. You may even have to put them on a performance improvement plan. You can and should expect as an employer to have employees that do their jobs, but that does not mean you can let go of someone just because of their age.
Again, any discrepancy on this, if you're confused, always call Lior 1-855-821-5900. Also join us weekly pretty much across the country on our radio show. Some are half hour, some are a complete hour. Always the opportunity for you to call in, ask your questions. You may appear, your call anyway, on this show. Phone call number 1 for this week. Lior's coming up right now.
I was working for the same company for 7 years. Within the company, a few times I was working in one division, moved around, and then another time I was in another division, but always within the same company. And then the last division that I was in closed down because they just weren't making any money. And they offered out like 6 weeks of severance. Is that typically enough?
What kind of a job and how old are you?
52, entertainment, managing.
All right.
So let's assume that there's nothing nefarious about this termination, that the company is letting him go because, business is not going great. They're not letting him go because of his age or medical condition. The company is allowed to let him go for most reasons, as long as they're not being discriminatory, so long as severance is paid. So whether or not we like the reason, agree with the reason, our job is not to deal with that. Our job is to make sure that he gets proper compensation. So we know after about 7 years that he was offered 6 weeks of severance. The real question here is that enough? Well, I'm going to spoil it to you and then I'll give you more detail. It's not even close to being enough. Not even close. He's owed much more than that. This probably goes back to the old nonsense that if you're let go, you get a week per year of service. Not true. Not even close. You are legally owed significantly more than that. So let's now get right to the meat of it. How much is he actually owed? Well, for that, I'm going to show you how you can find out how much you're owed. We're going to use the severance calculator tool. We're going to go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. Use the severance calculator tool. Let's see how much severance he's owed, because remember, it's not 6 weeks. So we know he's been there for 7 years or so of service, 52 years of age. We don't know exactly his job, but we know he was offered 6 weeks of severance. Well, you see he's probably owed anywhere from 8 to 9 months of severance. 8 to 9 months. Well, what a difference between that and 6 weeks. So yeah, he's been wrongfully dismissed, even though the reason of being let go is legal. He's been wrongfully dismissed because he's owed much more than 6 weeks.
And that's huge, Lior, because based on that difference in severance, I mean, he's not an old guy, but he's 52. It's still not going to be that easy for a guy that age, trust me, at that age, to get a gig. It could take some time. He needs that cushion, right?
Well, he's probably not going to find a job necessarily in a few weeks, but he may well find one in 8 to 9 months, which is exactly why you get that substantial severance. It's intended to reflect how long it could take you to find another job. To look at it like an insurance policy. You need that money because you may not have other money. You still have to pay your bills, your mortgage, your taxes, etc. So make sure you don't accept less than what you're owed, or unfortunately, you'll end up with less money than what you should have.
All right, good stuff. Phone call number 1 right there. Phone call number 2. Let's roll that one now as well.
I've been back at work for about 3 years on modified work due to a disability. My doctor had taken me off just coming into the new year on sick leave. I got a termination notice in the mail.
Do you know the reason?
They're saying it's performance related while I was there. There were some issues relating to, there was accommodations that my doctors had ordered. When they didn't follow through on them, it led to performance issues.
Something smells bad here. That's not passing the sniff test at all.
It's not. And you know, we were talking at a recent show about accommodation and the employer's obligation. This is another prime example of that. This clearly is a situation where an employee could have worked, wanted to go back to work, had a doctor tell exactly the employer what the employer can do to make this person come back to work. And the doctor says, no, that's just too much of a headache for us. We don't want to do that. Wouldn't it be easier if this person is just out of our hair? Well, guess what? Illegal. Your employer cannot let you go because you're sick. Your employer cannot let you go because you're unable to work and getting better. Your employer can't let you go because you need accommodation. They can't ignore that accommodation request. So what happens is if you have a doctor's note that outlines the accommodation that you need, your company has to find a way to make it work. Modified hours, modified duty, maybe working from home. Not up to me, not up to you. It's up to your doctor. Once you have that doctor's note, that doctor's letter, it's up to the company to make it happen. If they don't, human rights violation, that could be a constructive dismissal as well. So get that doctor's note. It's such a powerful thing. And if your doctor doesn't abide by it, does anything to you in the face of such a doctor's note, you call me right away.
All right, coming up here momentarily after the break, what you need to know about performance plans, that is on the way shortly, and phone call number 32. So stick around for that as we continue lots more of the Employment Law Show. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back to the Employment Law Show. Good to have you stick around through that break. We played 2 phone calls from our long-running radio shows across the country. Phone call number 3 is coming at you right now.
I worked for a construction company as a project coordinator. So what I would do is residential construction. I would bring in trade work. I would overlook them, distribute checks 40 hours a week for 7 years. So what they're telling me is there's not enough work and they want to let me go. It titled me as like a contractor. I'm just trying to see where I can go from here.
Were you working exclusively for this company or were you working for other companies?
No, exclusively.
The old construction worker don't get severance thing, huh?
Well, you know, it's more than that, because oftentimes companies say with the construction employee, even if you're a regular employee, you don't get severance because you're in construction. That's false. Well, this company is taking it up a notch. They're saying, well, you're not even an employee. You're an independent contractor. Well, no, not so fast, not even close. He has a regular job. He's been doing it for 7 years, working 40 hours a week. I don't think he could be more of an employee if he tried. Remember, substance over form. If anyone could just be a contractor, well, every person that has a job could just be called a contractor. And guess what? We wouldn't need employment laws because no one would be an employee. Well, it doesn't work that way. If you look like an employee and act like one, no surprise, you are an employee. So this person is an employee. Doesn't matter that the company says that he's not. The law makes that decision. Not me, not the company. The law does. Why is that important? Well, it's important because as an employee has the rights of an employee, in this case also the right to get severance. He lost his job. So yes, because he's been misclassified, because he is an employee, he's owed severance after those 7 years. It could be as much as a year's pay. A lot of compensation there. Same with you at home. If you work for one company, if you've been doing it for a while, you're probably an employee, even if the company that you work for says otherwise. By the way, if you want to know if you're an employee or a contractor, we have a tool for that. You go to pocketemploymentlawyer.ca. We have a tool there that allows you to find out if you're a contractor or an employee, of course, free and anonymous, so check it out.
Okay, main topic, here it is for the day, what you need to know about performance plans. Let's get it as point number 1, Lior. Employers can place employees on performance improvement plans. How about that?
So they can. So you are legally allowed to be placed on a performance improvement plan. There's no law that says that you can't. But, and this is an important one, it has to be done in good faith and it has to be legitimate. The company can't make it up. They can't do it in bad faith. They can't put false information. If the company legitimately has concerns and they have a plan in place to improve that performance, to help you, to support you, to be a better productive or more productive employee, they can do that. And of course, in a situation where they do that properly, that could actually be a very useful tool to help an employee achieve their performance target. So you can be placed on a performance improvement plan so long as it's in good faith.
There's always a but. And number two is that employees must follow implemented plans, however, can refute inaccurate criticism, right?
So if that performance improvement plan is legitimate, in good faith, it's going to outline what the expectations are of you, what you need to do or not to do. So yes, you should always follow that. Do your best to show that you've done your part to meet what's in that performance improvement plan. But if it's unrealistic, or let's say they set targets that can never be met, or it's not done in good faith, or information is missing or not accounted for, you have to say so. You have to send an email, and I say email because I want it in writing. You have to send that email saying, here's why this is not okay. I can never meet those targets, here's why, or here's why it's not accurate, or here's information that you did not account for. Put that in writing. If you don't, if you just put your head down, do your best, but don't respond, it's the same as if you've agreed with everything, and that could at some point be held against you.
We're talking about what you need to know about performance plans. Number four, and this one, Lior, is quite often where employers step up, or trip up anyway. Employers cannot change an employee's compensation or pay due to the poor performance, right?
So let's say your performance is a bit lacking and the company is going to work with you to improve that performance. That does not mean you can have your pay cut. That does not mean you could be demoted or have your hours reduced or cut. No, all those things can be a constructive dismissal. And the laws surrounding constructive dismissal continue to apply even if you're on a performance improvement plan or even if your performance needs improving. The company can legitimately work with you and do its part to improve your performance. By the way, John, if a company wants you to improve performance and puts you on a performance improvement plan, there's things that the company needs to do. They can't just say, do better and let us know when that happens. They have to work with you.
Roadmap, something, right?
Right, and also provide some support. Maybe there's extra training. Maybe there's additional support that the company can provide. That's how a performance improvement plan works. We call it a plan, not you do something, employee, and we don't care. So that all has to happen, of course, but in a situation where your performance is not where it should be, you still have a right to your same hours, same pay, same everything, otherwise potentially a constructive dismissal.
And then finally, this one, Lior, which is usually where it all leads, sometimes anyway. Performance plans are often used to build a case for an eventual termination of employment.
So we talked about performance improvement plan having to be legitimate, having to be done in good faith. Well, sometimes, unfortunately, that's not the case. That performance improvement plan is really there as a way to push you out or to give the company the ability to let you go without any severance. They're not done really to try to improve performance. So that's why the best way to deal with that, as I said, is to respond to it. If the company wants to let you go for cause, it's difficult to do, but you're playing into their hands by simply not saying anything, by accepting the performance improvement plan as is. So if there's something there to argue with, to quibble with, to correct, you should do that. And always remember, very difficult to terminate for cause. Even if your performance is not where it should be, legitimately, that does not mean you can just be let go for cause. If the company lets you go, they likely still owe you your full severance. So if you're let go, good performance, bad performance, or anything in between, you have to call.
Lots more to go here, but we'll take a short break before we get into more of your questions. In the meantime, write the number down, use it, and have a conversation on your own with Lior, member of his team, 1-855-821-5900, help@employmentlawyer.ca. Stick around, we're coming right back with more. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back. Employment Law Show. We continue to roll on here. There's so many ways you can reach out to Lior. The phone number, 1-855-821-5900. We always tell you about the email, help@employmentlawyer.ca, pocketemploymentlawyer.ca. That website was built by Lior, and including educating you with all the things we talk about on the show on web website. You'll have access to that severance calculator, which is key, free and anonymous, of course, pocketemploymentlawyer.ca. Beyond the radio shows and the TV shows, Lior also, he practices law, he does, trust me, but he spends a lot of time doing the live streams as well, and other lawyers in his firm. Facebook, YouTube, LinkedIn, you can join in, ask your questions at stlawyers.ca. For this week, Lior, let's get into this. Says, I've worked at my company for nearly 30 years. They're relocating to a new site nearly an hour away, and I do not drive. I was offered the option of this, to relocate or leave with 2 weeks' pay. As a 62-year-old employee in manufacturing, what are my options?
So this is an important question, and actually a fairly common scenario. A version of this scenario is something that I come across fairly often. So let's talk a bit about that. What happens if you're being relocated to a different workplace, a different location? Let's cross that bridge a bit and let's discuss it. So generally speaking, like with everything else, your employer has some ability to make changes. They can't be told you're making no changes whatsoever. So what does that mean for relocation? That means that your employer can relocate you so long as it's not a significant relocation. What's significant? Well, generally speaking, if the effect of the relocation is now that it means that you're going to now travel an extra hour more to get to work than you did before, well, that's significant. So it's not about the number of kilometers. That's not about the specific location. It's about how it impacts you. So if your employer now moved your office somewhere where it's going to take you an extra hour more than you did, that could absolutely be a constructive dismissal. That may mean that you don't have to accept that relocation, and if the net result is that you've lost your job now, the law considers that to be a termination. Now, the flip side of that, of course, is what if the relocation was 10 minutes away, you just didn't want to do it? Well, unfortunately, in that situation, that wouldn't be a constructive dismissal. So if you decide not to relocate, that may well be a resignation, and then you may not be owed anything at all. But in this particular situation with this caller from our radio show, that message that John read, that person was moving away or being relocated an hour away. They don't drive. It's going to be a significant impact. So yes, that is absolutely a constructive dismissal. So what's left for us to do now is figure out how much he's owed as a result of that constructive dismissal. For that, once more, we're going to go to pocketemploymentlawyer.ca. We're going to use the severance calculator tool. Let's see what that gives us. So we know this person has been there a long time, 30 years, 62 years of age, obviously in a manufacturing role. A company says, maybe we'll give you 2 weeks because we're nice. Well, you see right there, he's owed 18 to 24 months of severance, probably closer to that 24-month mark. So that's a significant amount, a lot more than 2 weeks' pay. So same with you at home. If you're being relocated somewhere far, you may have those same constructive dismissal rights.
It's interesting how when you tackle this one, Lior, you brought it to a function of time rather than distance. And that's a key thing to realize, because you and I may work at the same place. We may even live close together, but you drive, I have to take 3 buses. They relocate. You're like, no big deal. For me, it's a complete upheaval of my life, right?
Yeah, and I've spoken in the past with employees that did not drive and were working so close to their office, they could walk there. All of a sudden, they relocated. Now they have to take 2 buses each way. It may not be far from a kilometer standpoint, but the effect on the individual is significant. That's why the law doesn't look at kilometers. There's no hard and fast rule saying a relocation of this many kilometers is okay, otherwise it's not. It's the question of how it impacts you. Generally, the standard that I look at is an hour. If it's an extra hour, that's a big deal. That could be a constructive dismissal.
Let's go to terminationquestions.com, a website you can use anytime freely and anonymously as well. The question is this: I've been on maternity leave for almost 9 months. My work continuously emails me asking when I will return to work, although I've stated multiple times that I am not ready yet. It has been implied that I do not return within the next month. They will consider my job abandonment. Wow, what can I do?
John, this is where I just throw my hands up and say, really?
Yeah. Still,
yeah, in this day and age. So let's kind of break this down. Of course, if you're taking a maternity leave, parental leave, father or mother, doesn't matter, you have the right to be off. And during the time that you're off, you have a right not to be bothered, not to be questioned, not to be threatened, of course. And in most cases, you can be off up to a year and a half. And it's up to you to make that decision. And you're not required to tell your employer right off the bat, how long you're going to be off for. You may not know. It may depend on whether you find daycare. It may depend how you're feeling, how the baby is doing. There's many factors that go into deciding how long you're going to be off work. So what you do in this situation, you tell your employer, I don't know, and I will let you know when I've decided. And that's it. They cannot consider you to have abandoned your job. That's ridiculous. They cannot consider you to have resigned. They cannot let you go because of that situation. The law is very clear on that, and there's really no wiggle room here. So take the time that you need. Tell your employer when you know how long you're going to be off. Let them know. That's a fair thing. But until that happens, you're not required to tell them anything. And if they don't let you be, if they threaten you, if they do anything to your job status, man, oh man, there's going to be repercussions. Call me right away.
All right, we always wrap up this weekly show with employment law show. Rapid fire questions for Lior, and they're coming up right now. All right, right into this, pal. Here we are. First one, are all employees entitled to overtime pay?
So no, not all employees are entitled to overtime. There's some positions that are exempt from overtime. The biggest category is managers. Managers generally, if you're truly a manager, you're exempt from overtime. There's other positions such as firemen and policemen, and of course other individuals, professionals, doctors, lawyers, etc., that are exempt. But most people do get overtime, and even if you're on a salary, you still get time and a half for the time that you work overtime. So if your employer won't pay you overtime when they should be paying you overtime, that's a problem.
Next question, are employees owed severance years after they've been let go?
Well, severance is owed to you when you're let go, and you can pursue that up to 2 years after termination. So if it's been more than 2 years and you realize, oh, wow, they should have paid me that severance, but now it's been more than 2 years, in most cases, you're out of time and you may not be able to do anything about it. So don't sit on those rights. If you lost your job, you're staring at that severance letter, let's get this resolved now. Don't live with this. Don't forget about it. You may be walking away from significant entitlements that you have.
All right, next rapid fire question. Lior, does your employer need to have a good reason to fire you?
No. So in most cases, the company can let you go pretty much for any reason as long as severance is paid. That said, you cannot be let go because of a discriminatory reason.
Can my employer extend my probation period? That's the next question.
Well, practically speaking, no. You can really only be on real probation for the first 3 months of employment, to the extent that the goal is to let you go without any compensation. So anything more than that is just meaningless.
Love this question. Can employees record conversations that take place in the workplace?
You can, as long as you're part of that conversation. If you can record someone or some people speaking to you, they don't have to know about it, and it's legal to record. You cannot record other people's conversation. That could be a criminal violation. Don't ever do that.
Are employers able to implement temporary layoffs?
Well, in most cases, the answer is no. Unless you sign an employment agreement that gives the company the right to lay you off temporarily, or they've done it in the past and you allowed it to happen, in most cases, a temporary layoff is a constructive dismissal, meaning you can choose to consider that as a termination.
And finally, last rapid fire question for this week, Lior, can employees resign without providing notice?
In most cases, you are required to provide notice of resignation. Your employment agreement may state how much notice you have to give, or you otherwise have to provide a reasonable amount of notice.
Got her done. All 7 questions. Nicely done, pal. We'll leave it there for the week. You can always reach out to Lior now by phone, 1-855-821-5900, help@employmentlawyer.ca, or pocketemploymentlawyer.ca as well. We'll catch you next time on the Employment Law Show. Thanks for tuning in.